Today is February 8th, 2024, and the Indiana Supreme Court finally released their written opinion after the January 18th hearing. Some people say they appreciate my summaries of these longer court documents. This one is 21 pages, and I will include a link to the full document in the description below. But also today, Judge Gull delayed the February 12th hearing until March 18th, so I'm not doing a live chat on Monday where I was going to summarize these documents from today. So I decided to put this video out today for people who want to get the summary. The title was Petition for Writ of Mandamus under Indiana's Rules of Procedure for Original Actions, filed by Indiana Supreme Court. And the first page summary said the opinion was written by Justice Moulter, and Chief Justice Rush and Justices Massa and Goff concur. Justice Slaughter concurs in part, and dissents in part with separate opinion. As always, I do my best to lower the word count, but I never delete anything to push any one-sided narrative. Also, I consolidated the references to people, so I use last names Baldwin, Rosie, and Gull. Baldwin and Rosie are the defense attorneys. Gull is the judge. And for brevity, I refer to Richard Allen as Rick. We reinstated Baldwin and Rosie as Rick's court-appointed counsel because the trial court did not find that their disqualification was a necessary last resort after weighing the prejudice to Rick. We denied Rick's request for a trial within 70 days because he did not make that request in the trial court. And we denied Rick's request to replace Gull because he did not overcome our presumption of impartiality by identifying facts showing clearly that Gull is biased or prejudiced. Gull lacked the authority to remove Baldwin and Rosie without 1, considering other, less drastic options, and 2, weighing the prejudice to Rick. So not only would Rick's trial be delayed for many months if his original attorneys were not reinstated, if Rick were convicted, correcting the disqualification by vacating his conviction and ordering a second trial would produce years of further delay and an enormous waste of time and resources. That would not serve anyone's interests, not Rick, the states, the victims' families, the courts, nor the public's. These concerns can generally be resolved through discretionary interlocutory appeals, including a basis for a discretionary interlocutory appeal that the, quote, appellant will suffer substantial expense, damage, or injury if the order is erroneous and the determination of the error is withheld until after judgment, end quote. Or the, quote, order involves a substantial question of law, the early determination of which will promote a more orderly disposition of the case, end quote. And both the state and Gull argue that is the procedural route Rick should have pursued instead. But Rick effectively could not, which is another reason this matter is extraordinary. Gull struck their later filings because they were no longer counsel of record. Without the ability to file a motion requesting Gull certify her order for interlocutory review, Baldwin and Rosie could not pursue that avenue. Gull and McClelland responded that Rick should have had either his new public defenders or the appellate attorneys he retained for this original action pursue an interlocutory appeal, but it is not clear how either option was feasible. We simply don't expect Rick to untie that procedural knot, and he can cut through it with this original action instead. Our prior precedents pointed appellate counsel to the original action tool, and we declined to retire that tool for these sorts of situations now. Having concluded that Rick's petition is properly before us, we turn to its merits. Court-appointed counsel may be disqualified only as a last resort after considering the prejudice to the defendant. The Sixth Amendment to the U.S. Constitution, applicable to Indiana through the 14th Amendment's Due Process Clause and Article 1, Section 13 of our Indiana Constitution, guarantee criminal defendants the right to have an attorney assist them with their defense. For defendants who can afford to hire an attorney or retain an attorney to represent them for free, that constitutional guarantee includes the right to choose which attorney will represent them. The erroneous deprivation of this right constitutes structural error, which entitles criminal defendants who are convicted to automatic reversal and a new trial. But the right to counsel of choice does not extend to criminal defendants who cannot afford an attorney and can't find one to represent them for free. Rick can't afford an attorney, and he has asked us to reinstate Baldwin and Rosie as his court-appointed counsel, but he has no constitutional rights to choose which attorneys will represent him. He did not choose Baldwin and Rosie. Judge Gull did. Rick just wants continuity of counsel rather than his choice of counsel. Our court has been, quote, generally of the view that a trial court is limited in its authority to remove a criminal defendant's court-appointed counsel, end quote. The United States Supreme Court has not yet addressed whether there is a Sixth Amendment right to the continuity of court-appointed counsel, but it recognized the rights to due process and counsel overlap. Whether as a product of a defendant's right to due process or the right to counsel, the bottom line is a trial court cannot disqualify court-appointed counsel over the objection of both the defendant and appointed counsel unless A. disqualification is a last resort, B. disqualification is necessary to protect the defendant's constitutional rights, to ensure the proceedings are conducted fairly and within our profession's ethical standards, or to ensure the orderly and efficient administration of justice, and C. those interests outweigh the prejudice to the defendant. The Indiana Supreme Court was concerned that disqualifying counsel introduced structural error, at least as it relates to disqualifying them as privately retained pro bono counsel, and presents further extraordinary circumstances that prompt us to exercise our jurisdiction now to preserve the integrity of the trial proceedings going forward. Disqualification here was not a last resort. Gull concluded that Baldwin and Rosie made 4 mistakes that demonstrated they may be unable to assist Rick with his defense effectively. Number 1, they failed to secure confidential case materials, including crime scene photos. 2, Baldwin misdirected an email, he says inadvertently, with confidential case materials to a non-party client, I entered here, Brandon Woodhouse, without timely reporting the mistake to Gull or McClelland. 3, Baldwin and Rosie made extrajudicial statements while McClelland's motion for a gag order was pending, which Gull thought might prejudice the case. And 4, statements in Baldwin and Rosie's motion to reconsider safekeeping order turned out to be wrong. But the record does not reflect Gull disqualified Baldwin and Rosie only as a last resort after balancing her effective assistance of counsel concerns against the prejudice to Rick that would result from substituting counsel. Each of Gull's 4 concerns could be addressed through a combination of procedural rules and court orders, including the gag order and protective order she entered. And trial courts maintain both statutory and inherent authority to compel compliance with their orders and the procedural rules through contempt proceedings and sanctions that include fines and even jail. Gull's protective order invoked the court's contempt power to enforce compliance, ordering that the parties cannot grant anyone access to discovery materials without the court's permission and without the person seeking access first signing an agreement subjecting them, quote, to the court's contempt powers, end quote. There was no finding that these tools were inadequate to resolve Gull's concerns. The only basis for disqualifying Baldwin and Rosie was Gull's concern that they could not assist Rick with his defense effectively. The Sixth Amendment's right to effective counsel, quote, imposes a baseline requirement of competence on whatever lawyer is chosen or appointed, end quote. But there is no suggestion that Baldwin and Rosie are out of their depth. Baldwin has over 30 years of experience, and Rosie has over 20 years of the same experience, including 3 murder trials and a previous certification to handle death penalty cases. Neither the state nor Gull argue that counsel's extrajudicial statements or the statements in their motion harmed Rick's defense. They do argue the disclosure of case materials undermines Rick's defense, but they don't explain how. And they don't argue these mistakes reflect that Baldwin and Rosie are incompetent to handle Rick's defense or explain why disqualification is necessary to protect Rick's right to the effective assistance of counsel. Neither the state nor Gull direct us to any case concluding that issues like these, either in isolation or combination, rendered counsel constitutionally ineffective or were sufficient to warrant disqualification. There's no showing that Gull's concerns outweighed the substantial prejudice to Rick from substituting counsel. Baldwin and Rosie spent a year working with Rick, investigators, and experts developing his defense, and Rick says he is ready to present it to a jury. The prejudice to Rick begins with the fact that information and momentum spillage is inevitable as one trial team hands a complicated case like this over to another. Add to that, Rick has already been in jail for about a year and a half now, and substituting counsel requires a 9-month delay in the trial date, with substitute counsel unsure whether they would even be ready by then. It has already been 7 years since the murders, and fact-finding only gets harder as time passes, memories fade, and evidence is lost. Quote, our disciplinary rules recognize that with the passage of time, clients risk the loss of rights, witnesses' memories fade, and evidence may disappear, end quote. The record does not reveal any weighing of these concerns. Because the record does not reflect disqualification was a last resort that was necessary after balancing Gull's concerns against the prejudice to Rick, Baldwin and Rosie must be reinstated. Rick's second request is that we mandate that the trial court order trial to start within 70 days. Rick and his attorneys prepared and signed a speedy trial motion, but they never filed it with the trial court. Until a trial court has refused to rule properly, there is no basis for relief in this court. Baldwin and Rosie remain free to make such a request in the trial court. Rick's third request is that the Indiana Supreme Court appoint a new special judge to avoid the appearance that Gull is biased against the defense. But Rick has not stated facts showing clearly that Gull's disqualification is required. We begin with the presumption that a trial judge is unbiased. To overcome that presumption, the party seeking disqualification must identify facts reflecting the judge's actual bias or prejudice. Our law is well settled that prejudice is not inferred from adverse judicial rulings, and that is all Rick identifies here, Gull's adverse ruling disqualifying counsel. No doubt that adverse ruling was significant, but nothing in the record suggests Gull's decision emerged from bias or prejudice against Rick. Just the opposite. Gull explained she disqualified Baldwin and Rosie because she was trying to protect Rick's right to the effective assistance of counsel, and we don't minimize her concern. She faced a significant dilemma given her conclusion that Baldwin and Rosie were no longer effective. If she left them in place and Rick was convicted, the conviction might have been vacated through post-conviction proceedings based on ineffective assistance of counsel. Or if she disqualified Baldwin and Rosie and Rick was convicted, then the conviction might have been vacated because she infringed on Rick's right to the continuity or choice of counsel. She was in a tough spot either way. Though we've determined the record does not support her disqualification decision, we reach that conclusion with the benefit of weeks to consider the issue, thorough briefing and oral argument from excellent appellate attorneys, and the benefit of 5 justices and their staffs poring over the record, authorities, and arguments. Gull did not have those luxuries. Nor does Rick point to anything suggesting Gull is biased against Baldwin and Rosie. She said their mistakes reflected, quote, gross negligence, end quote, and was concerned the representation was ineffective, but, quote, judicial remarks during the course of a trial that are critical or disapproving of, or even hostile to the parties or their cases, ordinarily do not support a bias or partiality challenge, end quote. That is, unless they reveal an opinion that derives from an extrajudicial source or reveal such a high degree of favoritism or antagonism as to make fair judgment impossible. Gull said Baldwin and Rosie made mistakes that rendered the representation ineffective, but her statements were not based on any extrajudicial source or any experience outside this case. Instead, her statements were based entirely on her observations within this case. And while her conclusion that Baldwin and Rosie were constitutionally ineffective was too harsh, she was not wrong to be deeply concerned that sensitive case materials had leaked. Though she mistakenly hit defense counsel's eject button instead of the case's lockdown button, she was right to try to get the situation under control quickly and decisively. Her efforts did not reflect any bias or prejudice, and Rick does not identify anything she has done that demonstrates she is not impartial. We therefore deny Rick's request to replace Gull. Conclusion: having granted Rick's request to reinstate Baldwin and Rosie and denied his remaining requests through our January 18, 2024 order, this opinion terminates the original action proceedings in this court. Petitions for rehearing or motions to reconsider are not allowed. Chief Justice Rush and Massa and Goff concur. Justice Slaughter concurs in part and dissents in part with separate opinion, which I'm about to read now. So these next few slides are Justice Slaughter concurring in part and dissenting in part. Rick fails to meet the demanding threshold for obtaining the extraordinary relief he seeks. He establishes neither that Gull breached a clear legal duty entitling him to an unquestioned right to relief, nor that an ordinary appeal would provide an inadequate remedy. Thus, I concur to deny Rick's requests that we replace Gull and order a trial within 70 days, but I respectfully dissent from ordering the reinstatement of Baldwin and Rosie. My objection has less to do with the court's legal analysis than with its bottom line issuance of a writ, given the procedural posture in which the issue of attorney disqualification comes to us. Had this issue arisen in an interlocutory appeal or after a final judgment, I would be more open to Rick's argument Gull made an error in threatening to disqualify Baldwin and Rosie after finding them grossly negligent and incompetent. But by seeking relief through an original action, Rick takes on the onerous burden of satisfying its exacting requirements. Original actions are viewed with disfavor and cannot serve as substitutes for appeals. We do not issue writs to establish rights or define duties. A writ is warranted only to force an official to perform a clear legal duty or to grant an unquestioned right to relief. A writ will issue only where the trial court has an absolute duty to act or refrain from acting. We will not intervene if an appeal will afford an adequate remedy. The regular appellate process must be wholly inadequate to compel us to action. Rick falls short in both respects. Then they have 3 more sections. Section A. Gull did not violate an absolute duty in dismissing Baldwin and Rosie because Rick does not have an unquestioned right to keep them. The Sixth Amendment protects Rick's right to effective counsel, Wheat v. United States, which we heard this Wheat case a bunch of times on January 18th. The right to counsel of one's choice is not absolute. Trial courts have wide latitude to balance this right against competing interests like fairness, our profession's ethical standards, and the court's scheduling needs. The aim is to guarantee an effective advocate for each criminal defendant and not to ensure that the defendant will inexorably be represented by the lawyer whom he prefers. While Gull's actions raise a potential constitutional problem, under current law, it is far from clear she exceeded her authority. To justify its award of relief, the court must fashion a new rule against which to adjudge the trial court's actions below. Trial court cannot disqualify court-appointed counsel over the objection of both the defendant and appointed counsel unless A. disqualification is a last resort, B. disqualification is necessary to protect the defendant's constitutional rights, to ensure the proceedings are conducted fairly and within our profession's ethical standards, or to ensure the orderly and efficient administration of justice, and C. those interests outweigh the prejudice to the defendant. Then, having announced its new rule, the Indiana Supreme Court proceeds to find the trial judge breached it. The problem is this rule did not exist previously. The opinion cites nothing from our court or any court establishing this rule. Yet despite being unable to identify the source of the rule imposing the supposedly clear legal duty, the court awards extraordinary relief anyway. The court is not even sure of the rule's constitutional source, be it the, quote, defendant's right to due process or the right to counsel, end quote. The existence of such a duty is anything but clear if the court must patch together its rule out of quote-unquote whole cloth to justify today's result. On the merits, I do not necessarily quarrel with the rule the court announces today. It appears to strike a reasonable balance between the competing interests of a criminal defendant's right to counsel and a judge's duty to ensure the defendant receives a fair trial. He wrote this next 2 words: "My beef is with our after-the-fact application of this newly minted rule to award mandamus relief against Gull, who did not have the benefit of our rule when she acted. For this reason alone, I cannot join Part 1. Our original action rules do not permit issuing a writ when the trial judge's duties are unclear or the law is unsettled. Original actions are for clear-cut cases that apply settled law, not for cases like today's that announce new legal rules. The latter is what appeals are for." Section B. Rick does not make the case that an appellate remedy would be inadequate. This case could, and thus should, have been brought as a discretionary interlocutory appeal after Gull dismissed Baldwin and Rosie and barred them from entering a pro bono appearance. There is no reason to presume Rick's original action counsel could not have pursued such an appeal on his behalf. Had Gull refused the request and Rick been convicted, he would have had the ultimate appellate remedy, automatic reversal of any convictions based on his claim that the judge's disqualification of counsel amounted to structural error. Either appellate remedy, on interlocutory review or after final judgment, would have provided Rick all the relief to which he was entitled. Section C is the last slide. The court rationalizes its writ by claiming we have repeatedly reviewed attorney disqualification issues in original actions. In fact, our case law does not bear out a pattern of issuing writs in disqualification disputes. Of the many cases the court cites, we issued a writ in only 2. The court today flouts our original action rules to award extraordinary mandamus relief in favor of Rick and against Gull. In doing so, we allow Rick to short-circuit the appellate process, muddy our own jurisprudence in this important area, and invite future deviations from our rules. In my view, these institutional costs far outweigh the benefits to Rick. For these reasons, I respectfully dissent from Part 1 of the Court's opinion and concur with Part 2. That's it for the summary of this 21-page document. Again, I will include the link to the full document in the description below.